Today is Thursday, October 14th, 2021. The time is precisely 9 a.m. This is our weekly community development meeting. We do have a couple of items for consideration this morning. Attending Commissioners Duncan, Brooks, and Filios. And I'm going to ask Mary, would you please lead us in the Pledge of Allegiance, please?
My pleasure.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. Do we have any conflict or potential conflicts of interest? No. Hearing none. So the first item is a reconsideration hearing, and this is a potential action item. And it's a public hearing, in fact, so we can take testimony. It is case number CUP for conditional use permit 20-0012, a request by Les Votter for conditional use permit to establish a mini storage facility on an approximately 6.45 acre parcel of land in the agricultural zone. So Director Callahan, I'll turn it over to you.
Thank you, Commissioners. Good morning, everyone. Before I begin, I just want to take care of a housekeeping matter. We, the staff, missed an email that Scott Brown sent us that's useful information in the way of background exchanges of information between FEMA and my staff and others, and all leads into something I'll talk about in a few minutes. But now that it's in front of you, it's part of the record, and we'll give it an exhibit number.
B1000.
Also, I want to remind you that reconsiderations are different from the usual public hearing. They're conducted differently, and your decision-making is different. I'll just point out quickly that the starting point for a reconsideration is Idaho Code 676535, and I have copied that and put it in front of you and highlighted what, to me at least, is the pertinent part, which is that the reconsideration must identify specific deficiencies in the decision for which reconsideration is sought. I will use that as a jumping off point to remind you this is the case the hearing examiner heard twice, and then you heard it, and the hearing examiner and you decided to approve. We think, we the staff, that that was a rational decision. All of it is expressly laid out in your order of decision, and on the hearing examiner's docket, which I have on the screen and you have in your electronic packet, it has a great deal of information ranging from our original review, I'm just going through it very quickly now, to various information we received from various sources, including FEMA, engineers, and etc. So again, without belaboring the fact, I'll just say that we think this is adequately covered. I've read through Ms. Henderson's request for reconsideration. I find that the information she cites has been dealt with previously. And so I don't believe that it meets the state law grounds for pointing out things that are wrong. That's my personal opinion and professional opinion. At this point, I think I've really covered what I wanted to cover, but I'm here for any questions in case you have them.
Any questions for David? No? Okay. So we have two requests for testimony. And I'm sorry.
The appellant gets a chance first, and she came in last. I don't think she's filled out one.
But yeah, the appellant is not here anyway. So go right ahead, sir.
So this is a
You're being,
reconsideration.
okay, so it's Ms. Henderson that's going, yeah, okay.
So under our rules, the appellant gets to speak first.
And in this case, it's Ms. Henderson. Ma'am, do you want to do you want to speak?
I can't hear you very good.
Oh, okay. Sure. If you prefer to remain seated, we can get you a mic.
That's all right, I can go right up here.
Okay.
I've called several insurances on this piece of property, and two of them referred me definitely to their other thing for FEMA, and no one that I've called will insure this position. I can't hear you.
Can you give
Yeah, we
them
need-
your name and
Oh, I'm
address?
sorry.
Yeah, your name and address. Go
sorry.
right ahead.
Okay, I'm sorry. My name is Nancy Henderson. I live at 11609 South 4th of July Creek Road in Cataldo, Idaho, 83810. I'm sorry.
Go right ahead, ma'am.
Okay, and I understand two of the insurance companies referred me to their FEMA part. They said they wouldn't insure anything in any kind of a floodplain, or some of them said earthquake, storage, and, I called my insurance company, which is Farm Bureau, and he said, oh, we'll insure if you want to store some of your stuff as long as you have your household insurance. I said, what if it's in a flood zone X? He said, nope, you have to get FEMA. So, they should be advised that they have to have particular insurance. That's one thing I was worried about. And something else, all the elevations are, according to the internet and what I did with a mapping idea, they're not right. Not any of the elevations are right. The bridge, now, this is John Graves. Now, he's the head of Susie Sarpom at Washington, D.C., FEMA. John told me the bridge was 2124.6, and that's wrong, because the bridge is higher than that property, and the property is supposed to be 2150, something like that. I haven't got the exact figures, but I think the Loma is wrong. I've tried to get a young man, his name is Josh Enterline. Now, I'm not sure that's how it is. I have the spelling on my computer, on my iPad. I emailed him. He emailed me back and said that the Loma may be right, but it may be old information, and the Loma may not be correct on that property. And because we live in the valley, for a plane to fly over, they have to fly north and south to be able to get it, because you go from one mountain to the other, and it's maybe 3,000 feet between them. We're in a low valley. It's hard to get a Loma there. And that's what he said, and I just object. This morning when I got up, there was another semi parked over there. It was a Buell chip truck. I used to wake up at 3 o'clock in the morning during the summertime, because you'd have 3 or 4 semis sitting there from Buell. And they'd start their engines up at 3 o'clock. And I left my windows open because it cools the house down, because we don't have air conditioning. So I was upset, and I turned him in. It wasn't commercial then, never has been, but it always has been a floodplain, whether they say so or not. And I don't care what your Loma is, what Susie did, because even Tate, the surveyors, couldn't even tell me how they come up with the elevation there. Now, if I called him, he said he don't remember, it's been too long ago. Well, I would know how I come up with it 10 years from now if somebody asked me about a particular piece of property. Maybe he didn't do the surveying, though. Maybe one of his people did. So I'm not sure about that. But I still object to it, and I know that you guys have made your decision and everything, but I have a question. I want to know if he's gonna be able to store and park semis over there. Is this in the contract, or is this in any of the, because if it's only in the fenced area, behind that fenced area, there's room still for other things, but just because there was one there now, and I got several pictures of them being there just since we had the last meeting. Other semis of all kinds, trucks parked there, a camping trailer parked there. I don't know whose it was. I don't know what, could have been somebody he knew, which probably would be okay. But, yeah, I want to know, I'd like to know and have it realized that semis shouldn't be parked there. They should have never been parked there, but they have been. Because they are DOT and they're commercial. And this has been years, 10 years. Of course, she didn't own the property all that time. Guy in Bathroom used to own it. I think his name was Donningswith. And I don't know when it was transferred, but that's all I have to say.
Okay.
Thank you.
Hold on, ma'am. Maybe there are any questions for Ms. Henderson? No. David, did you want to respond to anything?
Semis are not before you this morning.
Pardon?
Semis are not in front of you as part of this hearing. That's a question we can answer outside of this hearing.
Okay, fair enough. Okay. So what Director Callahan is saying, Ms. Henderson, is that if you want to talk with him after the hearing,
I can't hear you very good. I'm sorry.
I'll speak with you after the hearing.
Okay.
okay, fair enough.
That is, you have to kind of, I worked in a factory with a
Okay.
lot of noise. Okay,
It's okay. Well, thank you, ma'am.
thank you.
Okay, so we have two other folks who wish to speak.
Mr. Chairman,
Yeah,
just
go
for
right
the
ahead.
record, I said everything I think I need to say under the introduction, under the rules before you. Now would be the time for anyone else that wants to speak on behalf of Ms. Henderson. If there is no one else, then you defer to the county's case in chief. I will just add at that point what your options are today, because I didn't actually read them into the record. And then you go to testimony and evidences in support of the county, which in this case would be the applicant.
Right. And so I have two here that indicate opposition, but I presume the opposition is to Ms. Henderson's claim, to the reconsideration.
Yes.
Right. Okay.
In that case,
And that's
may
it.
I just mentioned as the county's case in chief, other than what I already said, you have essentially, as a reconsideration, these options. You may affirm the decision, reverse or modify based on the evidence before you today. And you may also remand the matter back to me or the hearing examiner. That's the statutory requirement for this morning's hearing.
Okay.
Your options, I mean.
Any questions for David? David, I have one. I don't have time to look over it again, but when I reviewed this a couple days ago, and correct me if I'm wrong here, were there two different hearing examiners that heard this? Was there one and then a second one?
I honestly don't remember, but the applicant would.
It was the same one?
Okay.
There was something in the narrative.
Joan.
I'm sorry?
That would be Joan Woodard.
Okay. There was something in the narrative where the hearing examiner seemed to express that if they had heard this again, there might have been a different result. Did I read something wrong?
I believe you read wrong.
Okay. Or maybe it was just a consideration regarding the floodplain, something to that effect.
Well, you have a full copy of the hearing examiner's response.
I do.
And if they actually said that, it should be in there.
Yes, it should, but at this point, I don't know that I want to take the time this morning to go over it.
And I don't remember any such thing.
maybe it wasn't the hearing examiner, maybe it was one of the other inputs that came in, but there was something in there that indicated somebody was reconsidering something to do with the floodplain. But anyway, be that as it may. Bill, Leslie, do you have any questions? Okay. Is there a motion?
Oh, that could be.
So-
Oh, actually, we have to end deliberations, yeah. Go ahead, Leslie.
Okay, so just a point of order. So can we enter into deliberations, or do we need to have the,
I would
Jeff,
ask
speak.
the applicants if they want to testify as evidence in support of the county, which in this case is our decision, in your decision to approve. Because that's number 5 under testimony and submission of evidence in the land use and development.
Right. And I think I had asked them previously, but once again, did anyone want to come forth to speak in behalf of the county?
No, I think we're fine.
Okay.
I think the record is complete and it's all there. That's all I would say at the mic, so.
Okay.
Then in closing, Mr. Chairman, you
Go
should
right
ask
ahead.
Ms. Henderson if she wants to rebut anything.
Ms. Henderson, did you want to speak any further, ma'am?
I don't know of anything else I can say.
Okay. Is there a motion then?
I move we end end public testimony and enter into deliberations.
I second the motion.
Bill Brooks,
Aye.
Commissioner Duncan,
Aye.
Chair Philios,
Aye. Entering into deliberations, thoughts?
I don't see that this meets the criteria in statute. The issues brought up are mitigated by the conditions on it, and it's been heard 3 times now, so I'm in favor of denying the reconsideration and granting or affirming the decision.
Okay. Bill?
It doesn't clearly, it's outside the state statute, so I would agree on reaffirming the decision.
Okay. Yeah, I would have to agree. Some of the claims or arguments that Ms. Henderson poses have been rebutted, I think, substantially. There was also additional information that was provided after the close of the prior hearing, which really is inadmissible. And so at this point, I guess I would have to agree with my co-commissioner's motion.
I move that we affirm the decision in case number CUP 20-0012, a request by Les Bauwater.
Water.
I second the motion.
Bill Brooks,
Aye.
Commissioner Duncan,
Aye.
Chair Philios.
Aye, and the motion is carried. And so the request for reconsideration is hereby denied. Thank you, everyone. So moving on to, thank you, gentlemen. Thank you, Ms. Henderson. So moving on to a second item. David, you're good?
Yes, sir.
Which is a deliberation. It's an action item. It's case number APP 21-0001. It's a request by Pierce Family Trust to appeal an administrative decision by Kootenai County Community Development Director approving a 4-lot minor subdivision known as MIN for minor, 20-0103, Axis Cove, First Edition. David, please.
Mr. Chairman, this item, like the previous one, has different rules of procedure. It has identical rules in the way of how you conduct a public
Right.
meeting if you go there. At the moment, you're actually in deliberations, and the code allows you to make a decision under deliberations. You can also, like the previous case, decide that you want a public hearing, and you have been requested to have one by the appellant's attorney, Mr. Holmes. But that's entirely your decision. I would just note that you have 492 pages electronically in your file that says, in my view, everything that could be said about this. The hearing examiner agrees with staff that the findings were properly met. I'll just briefly mention that the central issue here was a 1967 prohibition against further division. That prohibition was actually amended and recorded in the county records in 1980, as I recall. Our attorney, the applicant's attorney, and the staff have all reviewed that, and we've all come to the same decision, that 1980 decision rescinded the 1967 prohibition. And so there's, in our view, is nothing that prevents this minor subdivision from going forward. I will be so bold as to say the 4 remaining concerns addressed by the applicant's attorney, the appellant's attorney, I mean, Mr. Holmes, are what my favorite attorney used to say are rubber arrows with no point. I will leave it at that, because I could go through each one of them, but I frankly think it'd be a waste of your time. And it's all in the record, and the staff has laid it out in the staff report for you almost ad nauseum. So unless you have questions, I believe you could make a decision now without going to a public hearing. But it's entirely your call. You can decide to go to a hearing if you'd like.
So our options are deny the appeal, go to hearing. Are those our only 2 options?
You can remand.
Back to you.
Okay. I looked over almost all 492 pages, and I tend to agree with staff's conclusion in the hearing examiners and the attorneys and everything. So I'm fine with denying the appeal.
Bill?
Yes, I agree. It was long and tedious reading, but I like rubber arrows with no points. That does sound much better if you say it in that. But I agree.
And I'm reading, I actually erred. I was confusing reconsiderations with appeals. Appeals, your options are to approve this summarily today or open it up for a new de novo public hearing.
Okay, yeah, I guess my inclination is to deny and to affirm staff's analysis. I think what's very telling is when I look at the conclusions of the law and the findings, the first item says the use of a minor subdivision subverts the major subdivision requirements of Kootenai County Land Use Code. I think that's something that we're going to have to wrestle with in the longer term here. You know, multiple minors that basically emulate a major without necessarily meeting the conditions. And while on the surface it appears to satisfy some of the requirements of a minor subdivision, I think there were certain things that were overlooked. So from my perspective, I have no desire to go forward to a public hearing. I would prefer to affirm the current findings. Anything else? Motion?
I move that we deny the appeal for case number APP 221-0001.
I second the motion.
Bill Brooks,
Aye.
Commissioner Duncan.
Aye.
Chair Philios.
Aye, and the motion is carried. So case number APP 21-0001 is hereby denied for reconsideration. I guess it would be, or
Thank
for
you,
a public
Commissioner.
hearing. You're very welcome. Time is now 9:25, and we still have one more item, which is the business segment of our meeting this morning. And it's a discussion of the relationship between building code exemptions for agricultural buildings and agricultural exemptions granted by the assessor's office. Director Callahan, go right ahead, David.
The easy takeaway for these two things is they are completely separate processes. We turn to the Idaho statutes where it tells us we must allow agricultural buildings that meet a certain definition. I'll read for you. And in that way, we allow them to go forward without a building permit, because that's what the state statute provides. It goes so far as to define what agriculture is, and it even goes so far as to say breeding, hatching, raising, producing, feeding, keeping livestock, dairy animals, swine, fur-bearing animals, poultry, eggs, fish. It goes on. The bottom line is if you're doing any of those things, that's sufficient proof. We ask for a person to tell us that by way of a one-page affidavit where they sign it and say that we meet this, and then we issue the authority to go forward, even though there's no permit. We do have a little, if I remember right, it's $100 fee just to process everything, but that's as far as it goes. The assessor's office has their own criteria that they review under state law to determine if you get a tax exemption. There are times when we happen to know about the assessor's determination. That makes this a lot easier, because if it meets the assessors, it almost certainly meets our criteria. But again, they're two separate processes. The assessor doesn't consult us when they do their thing, because they don't need to, and they actually shouldn't. And if we know about the assessors, we use it, but we don't always know about it. It doesn't matter, because we get the applicant to tell us here, and oftentimes they will tell us that the assessor is going to do this. So does that sufficiently distinguish things for you?
Yes, and so I guess the one case that was brought to me was one of the times where they did have an ag exemption, but they were being denied an ag building by your department, but it got straightened out. So.
I'm sorry.
That's okay. That's okay. But I guess you just explained it, the fact that it makes it easier for you when you know that the assessor has already made that determination.
Most of the time, the things they find are what we look for under state law.
Right, right. I just didn't know if there was any way to connect them to make it easier for your staff.
Unfortunately, I fear it's much like recorded divisions of land. They have to record them even though they're illegal.
Right.
And then, I'm not the assessor, I mean, the
Right.
clerk does. And
Right.
then the assessor has to assess, but they
Based
don't
on
tell us because there's no statute that says they should.
Right.
Either at the recorder's level or at the assessor's level. And so it's one of those silo things that you can thank your state legislature for.
Okay. Pat, did you have anything to add to this?
No, I really don't, not at this point.
Okay.
So where does that leave us?
Well, I hope it leaves you with the comfort level that we and the assessor are doing things the way we should.
Yes.
And that the blip you experienced was a one-off, or one might say statistical outlier.
So does that mean that both groups have the same definition?
I wouldn't
of
go
what
that
constitute-
far.
okay,
That's a
go ahead.
Pat question. Or we just need to ask the assessor, what state law do they look at? Do they look at the same one that I do? I don't know. That's beyond my ken.
Yeah. So
Well, they're both based on whether the property is actively devoted to agriculture.
Okay.
That's actually one of the local changes to the building codes that we make every year, is to try to fit that definition.
Okay.
To what the assessor has to consider.
Great.
So theoretically, they should be the same.
Great.
Well, there you have it.
Great.
So what does this change for you?
Nothing. This
Okay,
was
I
an
didn't think so.
informational item that
Oh, okay.
Commissioner Duncan wanted to dialogue.
Yeah, because like I said, there was a case where they had the ag exemption, they were being denied an ag building.
Okay.
But it just
okay.
was a communication issue, and it got worked out. But I just wanted to get more clarification and,
That, if it's the case I'm remembering, the applicant actually didn't give us one of these.
yeah, no, I think the one I'm talking about, they did.
Oh,
I know there's been a few in the past,
right.
but this particular one, I think.
And in the
they-
event, it's one of those
Yeah.
communication issues.
Yeah. But yeah, that one all got straightened out, but I thought, you know, is there a way to connect the two easier, but there's not, so.
I think really your issue is one of administration. We just need to keep the, in this case, permit tax knowledgeable of how we do these things.
Good.
Great.
Anything else?
No, not on this subject.
You can say goodbye to Mary.
Oh, is this
What-
your last
Is this
And
your
we're having a
last?
potluck if you want to come by.
today? Oh,
Tomorrow, yeah.
Tomorrow's your
Tomorrow's
potluck?
your last day?
But we have a potluck going today.
Oh,
Okay.
Thank you very much.
Thank you for your
Yeah.
service, Mary.
Thank you
Yes, very much so.
Been my pleasure. Pretty emotional right now, so.
Oh, okay. Well, thank you for
Yeah.
You say you'd
everything
like
you've
to
done.
stay some more?
Yeah,
Yes.
you definitely helped make my job easier.
Anyway, okay,
I've thoroughly enjoyed my time here. Thank you.
thank you.
Well,
And we
don't-
very much enjoyed having you, absolutely.
Don't be a stranger.
Amen. Okay then, so the time is now 9:31 and the meeting's adjourned. Thank you.